So how do we extrapolate an affirmative duty to protect from what is a criminal statute prescribing doing harm? It seems to me that's a leap that you haven't quite covered.
So, in my complaint, when I pled the negligence per se based on that statute, is the employer has a duty to employ the minor in a suitable, safe working environment, not to predispose them to a dangerous environment, to have them work third shift, for instance, to have them.
But you've already said that's not the case here. You've already acknowledged that working in the donut shop is not an inherently dangerous environment, and the work that the minor was doing is not inherently dangerous work.
Yeah, Your Honor, but my point is, if the donut shop, if you work, for instance, first shift versus third shift, the safety of the environment itself differ. For instance, if you're working, a minor working the third shift in a high crime area, I believe there's a higher predisposition of the minor being in harm's way. So if the employer is taking or has taken any steps to prevent such, to provide safe environment to this minor, then yes. So I think it's really a circumstance and factual basis to this. As far as what would be the suitable, proper job, and at what point in time, and the actual job position itself. Have I answered the question, Your Honor?
Yeah, I think so. Thank you.
Sure. So again, this is a robbery case that deals with a special class of people, which is minors, and this is based on the case law analogous, which is where, and I cited in my brief, where, for instance, where in Gracie, for instance, where there is a holding that there is a breach of this statute that deals with the special psychotherapist-patient confidential relationship. The court found that the impact rule does not apply and fashioned an exception. In April, for instance, in 2007, Florida Supreme Court, that was certified by the second BCA, where the doctor-patient, again, based on a statute, broke and the impact rule does not apply. And then the Brady case, again, based on a Florida admin code that was breached, the court said that it didn't bar recovery. But again, I think it's the actual premise of what the Florida Supreme Court has said when they said that in all these cases that's been quoted, that the Florida Supreme Court has recognized that the impact rule is not an inflexible, unyielding rule of law, so sacred that it must be blindly followed without regard to context. And this is where this case is.
Well, we have a case, Counsel, Rivers versus Grimsley Oil, 842 Southern 2nd 975, that is specific to robbery and specifically does not permit a case to go forward because of the impact doctrine in a scenario that is really quite similar to the one that's before us, right?
Yes, Your Honor.
What would we do if we were to follow your argument? How would we deal with the Rivers versus Grimsley case? Would we have to just say we're now receding from that? We're going to not abide by that holding? It seems to me that pretty well covers our situation.
Your Honor, in the Rivers case, this is a simple negligence case. No minors involved in that. Is that
the only distinction? Is that in Rivers we can't tell whether there's a minor? There's no reference to the minor being involved.
There is no minor involved in Your Honor.
So we would have to create a rule saying that we would handle we look at the impact rule differently if there's a minor involved, based on your understanding of the criminal statute that you've been discussing with Judge Rothstein-Ulicum?
Yes, Your Honor. So the statute itself.
So we would have to sort of create something that hasn't been created before in order to go where you want us to go. Isn't that a fair statement?
Yes, Your Honor. What I'm trying to do is to have the court to find an exception to the impact rule based on the 450.151 when you have a minor involved in a robbery. Correct.
Okay.
But, unlike the Rivers case, which is the statute itself, there
But
is
we
no,
would just sort of have to divine that out of the air, wouldn't we? There's really nothing that says that the impact rule shouldn't be applied when there's a minor involved.
well,
How do we read? We'd have to read that into the 450 statute, right?
yeah, so it's the legislature intended to have the minors protected by the employer by creating safe environment. By the legislature, by passing the statute, is basically admitting that the children are special vulnerable class of workers in our society, and therefore, when you have a statutory duty that has been breached under the my cause of action when I alleged as far as negligence per se, and that's where this special relationship.
The legislature could have also specifically said that if that's what they intended, could they not?
Well, the legislature would have probably excluded, civil cases where it deals with endangering a minor by a third party, for instance. But I don't believe that there was specifically stated, or that was intended here, Your Honor. So in essence, is by putting the child in harm's way without having particular safeguards, without having certain policies in place, without having certain procedures. When you have a robber, what are the certain policies you have to actually follow, protocols? I don't believe there is any, and that's where we alleged in the complaint when it was filed, and I believe this is and part of the gross negligence also count is based on other case law that I cited in my brief, such as the Kindron case from the 5th District, where there is a willful, reckless, wanton, and that's something that the jury has to decide. So but again, it's if we have a minor that's threatened at gunpoint, it is natural that this minor is going to experience emotional distress and will never be forgotten. But now but then putting that minor employee in just any environment without calculating the risk, that I believe that it's a violation of or a breach of the duty of the employer. Any further questions, Your Honors?
I don't believe so. You've got your full 5 minutes for rebuttal, counsel.
Thank you, Your Honor.
Thank you. Response?
May it please the court. Good morning. I'm Erin Kinzel with the Metzger Law Group, and I represent the appellee Legacy Donuts Hillsborough LLC. Your Honors, in this case, the trial court correctly dismissed the action because there is no cause of action for recovery for emotional distress damages following a robbery where there was no physical touching under the impact rule. And I respectfully urge the court to follow the precedent that this court set in the Rivers v. Grimsley case. This statute that's been cited by the appellants does not create a cause of action for emotional infliction of distress caused by robbery. And the case law on robberies with no contact is clear that this case cannot proceed. The court should not broaden the narrowed exceptions to the impact rule to allow for this type of recovery. There's no support in the statute that was cited. And first and foremost, Your Honors, I ask that the underlying court ruling be affirmed because the issue was never preserved for appeal. The plaintiff in the underlying case never filed a motion for rehearing of the order granting dismissal with prejudice. They never sought to amend the complaint at any time. And by doing that, they did not exercise the remedies that were available to them at the trial court level to address what they perceived as deficiencies in the court's ruling. And instead, when the order granting dismissal was issued on April 6, 2020, 2 days later, the plaintiffs filed this appeal on April 8th, 2020. The more procedurally correct option would have been to file a motion for rehearing within 15 days of the order or file a motion for leave to amend the complaint at some point. Aside from those procedural deficiencies, the trial court correctly dismissed the case under the impact rule. I'm going to just talk briefly about the statute that cited 450.151. I agree with Judge Rothstein-Yoakum that this statute's subsection does not create any affirmative duties for an employer. It prescribes employers from exploiting children. It's designed to apply to cases of trafficking, exploitation. It's not to exclude a minor or an employee under 18, in this case a 16-year-old, from working at Dunkin' Donuts. Although the word exploitation is not used within the statute itself, since this provision was passed by the legislature, the legislature has passed other acts regarding criminal cases involving minors where they have referred to this particular subsection 450.151 as exploitation of minors. And specifically, there's Chapter 39 of the Florida Statutes Proceedings Relating to Children, where the legislature defined subsection 35, as the definition section. They've said harm to a child's health or welfare can occur when any person, and then in subsection D, they state exploits a child or allows a child to be exploited as provided in section 450.151. There are two other statutes that refer to subsection 450.151 in the same way, and that is in the context of kidnapping and human trafficking, Chapter 787 of the Florida Statutes. And with respect to kidnapping of a child under age 13 or false imprisonment of a child under age 13, the legislature decided that if that criminal is also concurrently arrested and convicted for violation of subsection 450.151, that it would be an aggravating factor that would change the felony classification to a life felony. So, and in those two subsections in Chapter 787, they defined this subsection as saying exploitation of the child or allowing the child to be exploited in violation of section 450.151. So procedurally, like I said, we don't think that the case should be allowed to proceed because the issue was not preserved for appeal. The trial court correctly dismissed the case for failing to state a cause of action upon which relief can be granted. And even if the court were to have allowed amendment, there is no possible way that the plaintiff could have amended the pleadings that would have satisfied the rules without completely changing the facts that were alleged. They can't now in good faith change it to state that there was a contact when there was no contact. One last point that I would like to make about this subsection 450.151, it's not akin to a strict liability standard. It's not negligence per se. The cases that plaintiffs cited where a negligence, a strict liability standard would be imputed for a violation of a child labor law was Sloan versus Coit International, the Supreme Court of Florida case 1974, where a minor under the age of 16 was employed in a hazardous work environment, which was a factory setting, and injured himself. And that was, in that case, the law that was purportedly violated was designed to protect the class of people from harms envisioned by that law. And Tamiami Gun Shop versus Klein, which is the Florida 3rd DCA case from 1959, there was a law that you could not sell a firearm to a minor. And in that case, a firearm was sold to a minor, and then that minor discharged the weapon and shot themselves. Well, the statute prohibiting that type of behavior was designed to prevent the very activity that actually occurred, that injury. That is not analogous to 450.151. That statute was not designed to prohibit a minor or working as an employee at a donut shop. It was designed to protect against exploitation, trafficking, and those types of crimes. With that, I'll just ask if you have any questions, Your Honors.
Here's we do not, so we'll give it back to Mr. Badawi for his rebuttal.
Yes, Your Honor. So just a couple of brief points. As far as the statute is written very broad, and it's not only intended for exploiting minors. I believe if the legislature intended for the statute only for this specific reason or purpose, they would have actually fashioned a different language. So therefore, I think that the statute on its face is very broad to have a broader protection for the minors in the workplace. Additionally, and I addressed this in my reply brief, Your Honor, with respect to the cases that cited by the appellee here, with respect to the shooting cases, including the Rivera case, these are that there's no minor involved, there's no negligence per se as far as the violation of the statute of strict liability, and there's only simple negligence. In my complaint, the allegation is negligent training and gross negligence based on the Kindron case, and also based on the negligence per se for cases that were fashioned before, creating an exception under the state of Florida. So in essence, we're not asking for a new ruling or to deviate from the shooting cases. This is a very unique circumstance. It's the context is extremely different and the facts are completely different than what it's been cited by the defendant in this case. No further comments, Your Honor.
Thank you very much, Mr. Badawi. Thank you both. Appreciate the argument. And we'll move on to the next case now, which will be Miles Christian Hart and Barbara Christian Hart versus Wells Fargo Bank.